Guyana firmly believes, the frontier is what has been described. If it was not, then it is for you to determine it anew. But we do not think that this will take place, since there is no question about the validity of the award. In any case, this question has no bearing on your jurisdiction, which is the only issue that interests us here. Having said that, it doesn't seem that the parties are in a real disagreement on the scope of this controversy. They both consider it a territorial controversy, understanding that its resolution will inevitably pass through a decision relating to the validity of the 1899 award, with all of the consequences that flow from that decision. In a very explicit way, the 1981 Venezuelan ministerial declaration relating to the termination of the 1970 protocol, which suspended the 1966 agreement, and which is in your dossiers under tab 22, this Venezuelan declaration shows clearly that in the spirit of Venezuela, there is no doubt that the controversy concerned both the validity of the 1899 award and all of the consequences linked to that challenge. And I would like to quote from the Venezuelan declaration. The Geneva Agreement imposes a duty on the concerned parties to seek satisfactory solutions for the practical settlement of the issue. That is why Venezuela, from the beginning, has been willing to consider all the problems related to this matter, whether marine, political, economic, or social, and not to restrict it to just the examination of the nullity of the inexistent award of 1899. End quote. The parties have not been able to resolve their controversy, thus defined by negotiation, then by the good offices and the mediation from the Secretary General of the United Nations. Now it is for this court to rule on the validity of the award and on all of the questions that result from Venezuela calling this award into question. This is the only way that it will be able to fully and perfectly resolve this issue which has been submitted to it. This position is in accordance with the letter and the spirit of the Geneva Agreement, which I would like to quote, any outstanding controversy between the United Kingdom and British Guyana. And so here, I'd like to say once again, seeking satisfactory solutions, and not one solution, for the practical settlement of the controversy between Venezuela and the United Kingdom, which has arisen as the result of the Venezuelan contention that the arbitral award of 1899 about the frontier between British Guyana and Venezuela is null and void. Not the dispute regarding the validity of the award, nor the dispute regarding the delimitation of the frontier, but a wider one encompassing the others, which has arisen as the result of the Venezuelan contention, which brings the validity of the award into question. The objective is to come to a full agreement for the solution of this dispute by responding to any outstanding questions as specified in Article 4. This is obviously consonant with the mission of the Court, which is to decide in accordance with international law such disputes as are submitted to it, and it is for the Court to settle them fully. The Court cannot do this on a preliminary basis, can only do this, by ruling on a preliminary basis on the validity of the award. Consequently, the reservations that you have shown in the past having to do with applications bearing simultaneously on frontier delimitation and on questions of responsibility do not have a place here. In fact, here, this is a global dispute resulting from the challenge of the arbitral award delivered over 120 years ago that you're being asked to settle as a whole. Mr. President, we have endeavored to inform the the court of all of the legal and factual grounds on which the parties rely in the matter of its jurisdiction, in accordance with the instructions which were addressed to the two states by the order of 19 June 2018. As much as possible, we have taken into account the arguments that Venezuela has formulated here and there outside of your court, all at the same time while lamenting their ghostly presence, or maybe more likely their absence. Even virtually, their presence would have been very much welcome. Mr. President, members of the court, I would like to thank you for your attention, and in the absence of the Venezuelan party, I would like to ask you, Mr. President, to call to this virtual bar Sir Sridath Rampal, co-agent of the Republic of Guyana, to read our final submissions. Thank you.
Je remercie le professeur Pelé.
So I'd like to thank Professor Pelé,
the co-agent of Guyana, His Excellency Sir Sridath Rampal, to read the submissions of the government of Guyana.
Mr. President,
you have the floor.
Mr. President, eminent judges of the court, I will now close Guyana's oral pleadings by reading the final submissions. Guyana respectfully requests the court, 1, to find that it has jurisdiction to hear the claims presented by Guyana and that these claims are admissible, and 2, to proceed to the merits of the case. It remains only for me, on behalf of Guyana, to thank you, Mr. President and judges, for your patient hearing of our submissions in the novel conditions of our virtual hearing. And I end where I began, repeating Guyana's gratitude to the court for your dauntless embrace of new technologies to render justice on the law. I take this opportunity to thank as well the registrar and his entire staff, the outstanding interpreters, and especially the technical personnel who quite literally made this hearing possible. Mr. President, history will commend National Court of Justice of 2020 for your resolution in discharge of your high functions as principal judicial organ of the United Nations. It is an honor to be associated with this historic occasion. Thank you, Mr. President.
I thank the co-agent of Guyana. The court takes note of the final submissions which you have just read on behalf of your government. Before the end of this sitting, I would like to give the floor to Judge Benuna, who wishes to put a question to Guyana. Monsieur le juge Benuna, vous avez...
Judge Benuna, the floor is yours.
Je vous remercie.
Thank you very much, Mr. President. My question, as you've just stated, is directed towards the Guyanese delegation. It's worded as follows. In paragraph 2 of Article 4 of the Geneva Accord of the 17th of February 1966, concludes in an alternative, according to which either the controversy has been resolved, or indeed that all the means of peaceful settlement stipulated in Article 33 of the Charter of the United Nations have been exhausted. Now, my question is as follows. Would it be possible to think of a situation in which all of the peaceful means for settlement have been exhausted without the controversy having been resolved? Thank you, Mr. President.
Judge Benuna, the written text of this question will be communicated to Guyana as soon as possible. Guyana is invited to provide its written reply to the question no later than Monday, 6 July at 6 p.m. This brings the present sitting to an end. I would like to thank the agent and co-agent, counsel and advocates of Guyana for their statements. In accordance with the usual practice, I shall request the agent and co-agent of Guyana to remain at the court's disposal to provide any additional information the court may require. With this proviso, I declare closed the oral proceedings on the question of the court's jurisdiction in the case concerning the arbitral award of 3 October 1899, Guyana versus Venezuela. The court will now retire for deliberation. The parties will be advised in due course as to the date on which the court will deliver its judgment. Since the court has no other business before it today, the sitting is declared closed.